A federal judge just delivered a ruling that cut straight through the state's favorite defense in gun cases, and this time there was no ambiguity. The court rejected the government's public safety justification outright, refusing to give it even partial weight. Not delayed, not softened, not balanced against other interests. The judge made it clear that simply invoking danger, risk, or fear no longer satisfies constitutional scrutiny. That matters because for years, public safety has been the escape hatch states relied on when gun laws were challenged. This ruling shuts that door far more firmly than courts have done before, and it sends a message that reaches far beyond the single statute at issue. For decades, states have followed the same script when defending gun restrictions. They argue that firearms pose unique dangers, that modern society faces unprecedented threats, and that the government must have flexibility to respond. Courts historically accepted these claims, often treating the Second Amendment differently from other rights. The logic was simple. If a law was passed in the name of safety, it deserved deference. But that approach has been steadily eroding since Bruen, and this judge made it explicit that the erosion is intentional. The Constitution does not contain a public safety exception, and courts are no longer willing to invent one. In this case, the state leaned heavily on generalized claims about risk to the public and danger to law enforcement. Officials argued that striking down the law would make policing more difficult and expose officers to unpredictable threats. But the court refused to accept predictions as proof. Instead, the judge demanded historical evidence showing that similar regulations existed during the founding era or were consistent with the nation's historical tradition of firearm regulation. The state could not produce that evidence, and the judge treated that failure as decisive. Without history, the argument collapsed. What makes this ruling especially damaging for future gun laws is how clearly the court rejected the idea that modern conditions justify modern restrictions. The state argued that contemporary society is fundamentally different from the world of the founders, pointing to urbanization, population density, and advances in weapon technology. The judge rejected that framing entirely, explaining that constitutional rights are designed to endure through changing conditions. If modern concerns were enough to override constitutional text, the right would exist only at the government's discretion. The court went further, warning that allowing public safety claims to substitute for historical evidence would effectively erase the Second Amendment. If the government can always say a restriction is necessary to prevent harm, then the scope of the right would shrink whenever officials claim it is inconvenient. The judge emphasized that Bruen was meant to stop exactly that kind of balancing. Courts are not permitted to weigh policy preferences against constitutional rights. Their role is to enforce the Constitution as written and historically understood. One of the most striking parts of the opinion was its treatment of law enforcement deference. The state argued that police expertise deserved special consideration, suggesting that officers are uniquely positioned to assess risk. The judge flatly rejected that notion. Constitutional rights, the court explained, do not depend on whether enforcement is easy or difficult. The First Amendment does not yield because speech is disruptive, and the Fourth Amendment does not yield because warrants are inconvenient. The Second Amendment is no different. The court also dismantled the state's attempt to justify the law by pointing to the absence of identical historical regulations. The government argued that because certain modern weapons or circumstances did not exist at the founding, historical silence should not count against modern laws. The judge responded that the Constitution protects principles, not technology. The question is whether the type of regulation fits within the historical tradition of firearm regulation. If the government cannot identify an analog, the law is presumptively unconstitutional. This reasoning reflects a broader trend developing across federal courts. Judges are increasingly unwilling to accept studies, statistics, or expert testimony as substitutes for historical evidence. While such materials may inform policy debates, they do not answer constitutional questions. Bruen shifted the burden squarely onto the government, and courts are now enforcing that shift. States that built their legal strategies around empirical data are finding those strategies ineffective. The implications are serious. Many modern gun laws were drafted with the assumption that courts would defer to legislative findings about safety. Legislatures believed that invoking violence reduction or officer protection would insulate statutes from meaningful review. That assumption is no longer safe. Courts are scrutinizing laws more aggressively, and when states cannot meet the historical standard, laws that once seemed untouchable are suddenly vulnerable. Even if this ruling is appealed or eventually reversed, its influence will persist. Lower courts routinely look to persuasive authority from other jurisdictions, and this opinion provides a clear blueprint for rejecting public safety arguments. Litigants will cite it, judges will consider it, the reasoning will spread. Each time a court adopts similar logic, it becomes harder for states to argue that safety concerns alone justify restrictions. States now face a difficult choice. They can continue defending laws with arguments courts are increasingly rejecting, or they can attempt to reconstruct historical justifications that may not exist. Neither option is appealing. The more courts insist on historical grounding, the more exposed modern regulations become. This ruling underscores that tension and makes it impossible to ignore. The broader message is unmistakable. The Second Amendment is being treated as a real constitutional right, subject to the same analytical rigor as other enumerated rights. Courts are no longer asking whether a gun law sounds reasonable or politically popular. They are asking whether it fits within the Constitution's text and history. And for states relying on public safety claims alone, that question is becoming harder to answer every time a judge says no.